Always invite objections to your questions. Does anyone object to what I just said? Note the absence of objections and get them on the record. Now, how about getting your evidence onto the record? I might use the other party to do that. I might ask the plaintiff, did your client receive a copy of the notice of default on January the 2nd, 2008? If not, here's a copy. Would you mind reading that to me, please, so that I know that we both are singing from the same page? Or I might say to the judge, sir, I believe you have a copy of the notice of default, which was filed into the case under a notary seal on January the 3rd, 2008. Would you mind pulling that out, please? And just read it to me so that I know we both have the same document. Now, if he then says,
I'm not reading that into the record.
I might say, for on the record, why will you not read it into evidence, sir?
That document's not in my file. It's disappeared.
Really, sir? Who else has access to that file? Was it stolen? Has a police report been filed regarding that incident, sir? Now, if you cannot get them to read your evidence into the record, read it into the record yourself, if necessary, calmly and loyally. If they try to talk over you, speak louder. Make sure that you get that evidence on the record. Now, what if you're dealing with Bonds and he says,
well, this promissory note is bogus. It's nonsense. Absolutely nonsense.
Am I to understand you're claiming that a document recognized by a public official is hearsay? Is that your position? Are you suggesting then, sir, that the notary who issued the certificate of default is in error or is a liar, sir? For the record, are you claiming this is not a genuine negotiable instrument?
It certainly seems to have a veneer of legality, but I've never seen anything like this before.
Well, your own codes say it is. UCC 3104, UCC 3604. And as this is an Admiralty court, I can only assume that the UCC is in full effect here. Are you not aware of the statute that says if you decline payment, you are holding the liability? Or, Judge, with all due respect, are you an expert in negotiable instruments? Well, he has to say no, of course. And if he remains silent, I would get that silence on the record. Sir, let the record show that by your silence you admit that you are not an expert in negotiable instruments. Did you bring an expert with you? Do you have a certificate of protest from Treasury regarding that promissory note? Do you have a notice of dishonor from Treasury, perhaps? Is there a defect in the instrument? Do you have any first-hand knowledge of a defect in the instrument? Now, let me have a look at that. Oh, that's odd. It doesn't appear to have any markings on it. It hasn't been processed or cancelled, has it? So you're going to claim it's a bogus instrument when you haven't even put it into the system to negotiate. You are holding the liability, sir, and you have just confessed to misappropriation of funds. Now, remembering that we are there to pay, to settle, to close, and to act honorably, you are going to get the odd contempt citation when you start playing by your rules on their court.
One more word out of you, you little rapscallion, and I'll hold you in contempt of court.
So how do we deal with contempt? Well, first thing I might ask is, what kind of contempt, sir? Civil or criminal?
Why, civil contempt. Civil contempt, goddammit.
A civil contempt depends upon a contract. Without a contract, no agreement for performance exists. What is the controversy between you and I, sir? Where is the contract requiring performance? Where is the claim? How am I in contempt of a contract, sir? Produce the contract and I'll resolve this matter immediately. Bring it forth. Am I in breach? Have I failed to perform on that contract?
Oh, criminal contempt. Criminal contempt, I tell you, by Jove.
Criminal contempt requires an injured party and a claim. So I might say, who's making the claim? And where is the injured party? Are you making a claim, sir? You can also question the venue with regards to contempt. Sir, the law provides for two forms of criminal prosecution. One is under the common law and one is under Admiralty or military jurisdiction. Which do you presume you're going to charge me with? Now, if he says Admiralty, which is highly unlikely, I might say, I accept that charge, sir, and I agree to pay it right now pursuant to public policy. Who has a pen and paper so I can write my bond? If he says common law, which again is highly unlikely, I might say, really, sir, where is the injured party? Where is the affidavit of probable cause sworn by two witnesses with first-hand knowledge of the crime? Do you have any of those things? Now, when the questioning gets tough, A judge might try to cut it off by saying,
Ha! God's teeth, you nincompoop, I don't have to answer your questions. Now, we're not here to answer your questions today. Now, how would you like to plead?
"Is there some reason why you don't want to answer relevant questions and would rather hold me in contempt for asking them? What are you trying to hide here, sir? Is there some criminal activity that needs disclosing? Are you aware that I have a right to question this court's authority or anything else I don't understand, sir? Can you proceed without my understanding? Without making full disclosure to me of the law venue and the consequences of my decisions here today?" The judges have been known to get quite aggressive when under the pressure of intense questioning, and they have been known to lose it.
Mr. Anti-Terrorist, I am warning you, I am going to rip your head off your shoulders and throw you out of this court on your behind if you do not stop messing about. Now, really, let's play this game properly by my rules or not at all.
"Excuse me, sir, but I'm standing here shaking in my boots at your outburst. Are you okay? You're yelling at the top of your lungs and your face is red, you're foaming at the mouth, you're slamming the bench. Are you having a physical problem or a mental problem, sir? I'm really concerned about your health. You need to call a recess and compose yourself because the record shows that justice cannot be served here today. Or would you like to recuse yourself?"
Now look here, stop wasting the court's time. Do you understand the charges that you're under here today?
Now, unless you're ready to act like a creditor and pay those charges, I would certainly say, "No, sir, I do not understand." "Sir, am I obliged to understand those charges? Am I obliged to seize, grasp, or comprehend them?" Now, if I was a creditor, of course, and I was in there as a sovereign man, I would say, "Yes, sir, of course I stand under those charges. Where do I pay them? Let me get a pen." Chances are you'll get railroaded, and the judge will issue an order of some sort, and then you can deal with it commercially afterwards if you study in the right places. But there is always a remedy. There is always a commercial remedy. And with regards to commerce, your remedy comes after the fact. So when the police abuse you or abuse your rights, you can then deal with that commercially afterwards by using the commercial lien process, and I highly recommend you look into that. Now, the information I've given you in this broadcast is not exhaustive. I'm painting in broad brushstrokes. But I recommend that you look into acceptance for value. If a judge issues you an order, then give him a bill. Watch Robert Menard's videos with regards to that. You can have quite a lot of fun with that technology. There is a lot to learn. I'm very clear that I am where I am in my understanding today because of my teachers, Sam Kennedy, Winston Shrout, Jack Smith, to name but a few, who are paving the way in terms of developing this information and making it accessible for all of us to use. There is a chap called Mark Stevens who wrote Adventures in Legal Land here on YouTube. I highly recommend his work. He is very, very eloquent and very knowledgeable, and certainly worth your time. Never giving you legal advice, of course, just empowering you. Now, I would like to point out that there is a lot of misinformation out there too, and I highly recommend you develop a noise filter for all of this stuff, particularly when it comes to the 1099 process. You need to look at what is being said by the authorities regarding these matters. The Treasury might put out a post, or the IRS might put out a post. You need to learn to read that in a very particular way to see that sometimes they're actually giving you a clue as to how to perfect this process. Of course, the timid and the fearful will read it and immediately give up and return to the slave mentality. But I urge you, develop your filter and study carefully and follow people like Robert Menard. Read Mary Croft's book, How I Clobbered Every Cash Confiscatory Bureaucratic so-and-so and so-and-so. And I would also start to look at some of the forums. thinkfreeforum.org is a good one. Lots of information on there and lots of very knowledgeable people who can help you. They also have a UK-specific section. In fact, they have a worldwide section on thinkfreeforums.org, and you can pretty much guarantee your country will be in there somewhere. Robert Menard's new idea with regards to creating a society is also a very, very profound one, and certainly one that I would advocate. And I highly recommend you go to his site. If you visit his YouTube page, Mr. Mighty, M-I-T-E-E, I believe it is, you will find a link to the website there. I'd like to take this opportunity to thank my good friends in the UK, DZ, VC, HO. You know who you are. People who make an enormous contribution to me and I wouldn't be where I am without it, no doubt. I hope this information was useful to you, and that you can use it in some way, and that you will keep studying and keep empowering yourself. Thanks for listening.
Order in the court! Order in the court!
I'll have a cheeseburger.